Welcome dear learner. What we are taking the online course on Swayam portal, that is Understanding Competition Law, Theory and Practice, and I am your instructor, and we are continuing with the session and we are taking the fourth module, that is we are in fourth week, and this is the last session of this particular module of this week. And this week, with ending of this particular module, we are dealing with the exception and exemption. That means in today's session, we will discuss what are the exemption or exceptions are given under section 3 subclause 3, and the provisions is section 3 subclause 5 and the proviso of section 3 subclause 3. And the objective to discuss the exception and exceptional provision related to anti-competitive agreement. So before continuing with the exception, just to remind you that what we are dealing with in last session, that we were dealing with the vertical agreement and types of vertical agreement. And we have discussed that agreement, that is anti-competitive agreement, are such agreement which is prohibited under section 3 subclause 1 and subclause 2. There are two type of agreement under section 3 subclause 3 and subclause 4, that is horizontal agreement and vertical agreement. In last session, we have taken with the vertical agreement, and vertical agreement are such agreement which is in section 3 subclause 4, where the competitor, that means the enterprises, association of enterprises, or the person are engaged in agreement or comes within the understanding at the different stage of supply chain in the same supply chain. And this is called the vertical agreement, and there are particularly four type of vertical agreement which includes in vertical agreement and have explained in explanation given under section 3 subclause 4, like tie-in agreement, resale price management, exclusive supply and exclusive distribution, and refusing to deal. Let's delve into a scenario where a company A, leading manufacturer of electronic gadget, and a company B, a nationwide distributor with an extensive network, decides to enter into a vertical agreement. And in this agreement, company A agrees to supply its electronic gadget exclusively to company B, granting the distributorship's rights. And in return, company B commits to promoting, marketing and selling the electronic gadget to retailer and sell consumer within the specific geographical area. This vertical agreement outlined the terms and conditions that govern the relationship between the manufacturer and the distributor, illustrating a classic case of vertical interesting, that is business supplies chain. So with this, today we are continuing with what are the exceptions and what are the exemptions. Is there any exceptions of anti-competitive agreement? That means if there are certain event when enterprise or person or association of enterprise comes into arrangement or agreement for certain purpose, which prima facie comes within the meaning of anti-competitive, but that is not anti-competitive. Yes, there are certain scenario, that is under section 3 of Competition Act in India, prohibit anti-competitive agreement. Such agreement are deemed void under section 3 subclause 2. However, in section 3 subclause 5, carves out a specific exemption and the prohibition, ensuring that certain rights and activities are not unduly restricted by competition law. And this response will discuss under section 3 subclause 5 in detail with the scope, meaning and the rational case law and with the examples. Section 3 subclause 5 provides two key exceptions regarding the application of section 3, that is protecting intellectual property rights, and second one is export cartel. Protection of intellectual property rights is actually it is for the protection of someone's economic right. If you see section 3 subclause 5(1), which states that nothing in section 3 shall restrict the rights of any person to impose reasonable conditions necessary for protecting their rights conferred under specific or specified intellectual property laws. And the second one is export agreement, that is export cartel. Section 3 subclause 5(2) exempt agreement that realty exclusive to the production, supply, distribution or control of goods or provision of service from export from India. And this exception supports India's export-oriented economic policies by ensuring that agreement aid at facilitating export not hindered by any competition. So these are the two specific exceptions, or you can say exemptions, what are the given under section 3 subclause 5. One more important thing, that is in proviso, we will discuss in the last of this session at the last, but particular for this particular section 3 subclause 5, there are only two exemptions, that is IPR exemption and export agreement. What is the rationale and scope of this exception? If you see section 3 subclause 5, it actually reflects a legislative intent to harmonize competition law with other legal framework, particularly those protecting innovation and international trade. IPRs by their nature confer exclusivity, which could be misconstrued and anti-competitive under section 3. For instance, a patent holder restriction on other producing a patent product might limit some competition, but it is lawful exercise of their right. Section 3 subclause 5(1) ensure that such restriction, if reasonable and necessary, are not penalized. However, in terms of reasonable condition, introduce a safeguard implying that excessive or abusive restriction could still fall under the scrutiny. And the rationale is to balance the competition law with legitimate right of intellectual properties holder and recognize their IPR right inherently grant exclusive rights that may appear anti-competitive but are essential to incentivizing the innovation and the creativity. Similarly, the export exception under section 3 subclause 5(2) acknowledges that agreements facilitating export may involve coordination that could resemble anti-competitive behavior, that is price coordination and export market. By exempting these, the law prioritizes economic benefit derived from international trade over strict domestic competition enforcement. If you analyze in detail the section 3 subclause 5(1), that is IPR exception, you will find that it actually there is nothing shall restrict for the purpose to right of any person to impose the reasonable condition that is necessary for protecting their right, specifically the IPR right, whatever in Copyright Act, Patent Act, Trademark Act, Geographical Act or Design Act or any Semiconductor Act or any other law for the protection of IPR in force. And the IPR exception is conditional and for imposition of reasonable condition to protect the rights. This simply implies that the condition must be directly linked to the safeguard, the IPR, and it must not exceed what is necessary to achieve the protection. And any condition that goes beyond protection and cause an appreciable adverse impact may not qualify for the exception. In this regard, the Raghavan's committee report on competition law is very relevant, which observe about this protection of the IPR for granting this exemption, that all forms of IPR have potential to raise competition policy law problems. IPR provides exclusive right to the holders to perform a productive or commercial activities, but this does not include the right to exert restrictive or monopoly power in a market or society. Undoubtedly, it is desirable that in interest of human creativity, which needs to be encouraged and rewarded, intellectual property rights needs to be provided, and this right enabled to the holder, that means create to prevent other from using her invention or design to other creation, but at the same time there is a need to curb and prevent anti-competitive behavior that may surface in exercise of the intellectual property. In that sense, section 3 subclause 5 therefore exempts agreement relating to IPR under the laws specified therein from the applicability to section 3 subclause 1 and subclause 2. only reasonable and legal condition under those law are within the prohibition. This is a notable thing. Case that is Sri Samser Kataria versus Honda Steel, and the fact was like the car manufacturer like Honda, Volkswagen and Fiat entered into an anti-competitive agreement with their original equipment and authorized dealer restricting the sale of spare part in open market. These agreements mandate that dealers source spare parts exclusively from the manufacturer to their approved vendor, which was alleged to the violating of Section 3 subclause 4. What CCI observed that these agreements to be anti-competitive as they created exclusive supply and distribution agreement and limiting access to the spare part and inflating price to the consumer. And these argued, that means the manufacturer argued that their restrictions are reasonable under the IPR protection, but CCI denied. And the outcome is like CCI rejected the defense, holding that IPR protection is an exception and the restriction over the beyond what is reasonable. So the manufacturer were not merely protecting their right, but leveraging it looks customer into the aftermarket service. That's why CCI imposed a fine of rupees 25.5 crore to such manufacturer. One more important case, that is FICCI Multiplex Association India versus United Products Distribution in 2010, where the fact is like film producers and distributors agrees not to release film for multiplexes unless certain revenue share terms were accepted, raising allegation to cartel-like behavior under Section 3 subclause 3. The producers claimed that these terms were unnecessary to protect their copyright under the Copyright Act 1957. What CCI ruled that while copyright protection allowed control over distribution, the collective boycott by producers was not a reasonable condition for protecting IPR, and it was instead a concerted effort to manipulate market term, causing appreciable adverse impact on competition. So this case underscores the collective action on the grounds of IPR protection. Look at the detailed analysis of Section 3 subclause 5, that is export exception. What is export exemption under the subclause 2 of 3.5? The export exception applied to the agreement exclusively related to export, and this means the agreement must not have a domestic comparative impact on the qualify for the exemption. All India Tire Dealer Federation versus Tire Manufacturer in 2013, if you see, in this case, the alleged tire manufacturer colluded to fix export prices and allocate export markets, potentially violating Section 3 subclause 3, but they are arguing that it is for the purpose of protection and it is protected under Section 3.5 clause 2. CCI ruled that investigated whether the agreement exclusive pertinent to the export or had spillover effect on the domestic market, that is the price strategy. Evidence showed that the agreement influenced domestic supply and price as reduced export competition allowed manufacturer to maintain higher domestic price. The CCI held that the agreement did not qualify in Section 3 subclause 5.2 exception because it was not exclusively export oriented and caused an appreciable adverse impact on competition in India, and the penalties were imposed. So this case highlights that the export exception is narrowly construed and any domestic company are disqualified the exemption. Just see some practical example. Let's scenario. A pharmaceutical company hold a patent for a life-saving drug and license it to a single manufacturer, imposing a condition that license cannot sell the drug below a specified price to prevent generic from entering into market prematurely. Application of Section 3 subclause 5.1. C. If the price restriction is deemed necessary to protect the patent, it may qualify a reasonable condition. However, if the CCI finds that the restriction extend beyond protection, say to maintain monopolistic pricing after the patent economic value is recovered, it could be struck down as anti-competitive. And let's discuss one more scenario just to see the example of the export cartel. There are two textile exporters who agree to fix price for shipment to Europe to compete with Chinese manufacturer, ensuring higher margin, and the agreement does not affect their domestic sale in India. By application of section 3 subclause 5(2), the agreement would likely to be exempt under section 3 subclause 2 as it exclusively export focus and does not impact the domestic competition. So, these two exception what we have discussed is under exception section 3 subclause 2 and 3. Exemption for joint venture, which is basically not exemption but which is a proviso with attached in section 3 subclause 3, which exempt any agreement entered into by the way of joint venture if such agreement increases efficiency in production of supply, distribution, storage, acquisition or control of goods or provision of service. The term joint venture is very important. If you see the term, it has not actually defined in this act, but in general term, it means the cooperation of two or more individual or business in which each agree to profit or share profit, loss or control in a specific enterprise. And the joint venture exception under the proviso to section 3 subclause 3 of the Competition Act exempt agreement that form a joint venture for research, production, marketing or distribution, and provided they increases efficiency and don't impose restriction on competition. And this exemption allows parties to collaborate without violating anti-competitive rules as long as joint venture does not limit production, share market or harm competition, and is evaluated by the Competition Commission of India at the case by case. So, the two basic requirements under section 3 subclause 3 are such agreement should be a part of joint venture and they should be shown to increase efficiency in the supply of goods or service. So, if a conclusion, if we try to summarize the today's session, what we have discussed, there are particular two exemption under section 3 subclause 5 and there is one more exemption which is basically the proviso of section 3 subclause 3. Section 3 subclause 5 of the Competition Act provides critical exemption that safeguards legitimate IPR enforcement and export activities from broad competition and anti-competitive agreement. However, these exceptions are not cartel balance, each come with qualifiers, that is reasonable condition like IPR and exclusively for exports, that the CCI rigorously enforces, and case law demonstrate that enterprises must carefully structure agreement to fit within the exception or any overstep risk significant penalties and invigilance. For businesses, understanding the boundaries of section 3 subclause 5 is essential to leveraging these exceptions without falling afoul of competition law. And section 3 subclause 5(1) of the Act provides that the proviso of the Act, that is adverse effect on section 3, will not restrict the rights of any person to restrain any infringement or to impose reasonable condition as may be necessary for protecting any of this right which have been or may be conferred upon him under the various intellectual property rights states likes. Now, for today's session, there is a self-assessment question for you learner. Suppose XYZ, a leading manufacturer of electronic device, has a licensing agreement with ABC Private Limited, a local distributor, to sell XYZ product in India. And the agreement includes certain restrictions, and restriction is like first, trademark uses. ABC Private Limited is required to display XYZ trademark on all promotional material and packaging. Second, territorial restriction. ABC Private Limited is restricted from selling XYZ product outside India. And third one, non-compete clause. ABC Private Limited is prohibited from selling product that compete with XYZ. So dear learner, in this scenario, go with this scenario and this restriction and determine whether each restriction falls under the IPR exception or exemption under section 3 subclause 5 or not. This is for your analysis and for your thinking. Just go with a hint what I am giving you, that for each restriction you have to analyze with 3 questions. If you analyze with 3 questions, definitely you will get your answer. And the question is, does the restriction relate to the protection of IPR? Is the restriction necessary to protect the IPR, or does the restriction go beyond necessary to protect intellectual property? So on the basis of this hinted question, just to try to analyze this scenario and try to find out the answer. So with this, we are ending this particular module, which was regarded to anti-competitive agreement. So with this session, we will conclude this module and this particular topic, and in next week, in next lecture, we will come and we will discuss the particular module, that is abuse of dominant position. So for today, thank you very much.